Dear colleagues, the Ukrainian Association of International Law and the State Service of Ukraine for Ethnic Affairs and Freedom of Conscience have the honor to start their briefing National Minorities' Rights, International and Domestic Dimensions. My name is Roman Yedelev, and I am an Executive Director of the Ukrainian Association of International Law, as well as Associate Professor of International Law Department of Taras Shevchenko National University of Kyiv. Also, I am a moderator of our today briefing. The briefing is aimed at discussing legal and political issues of national minorities' rights, latest developments in international regulation, the best practices of national legislation in this sphere, as well as trends of Ukrainian legislation on national minorities amendments. A few words about our today way of work and some technical aspects. The briefing is recorded. Video and the full text transcript of the briefing in Ukrainian and English will be available on official websites, Facebook and YouTube pages of the Ukrainian Association of International Law and the State Service of Ukraine for Ethnic Affairs and Freedom of Conscience. Taking part in the briefing, you give your consent to it. The briefing will consist of the 4 keynote speeches and additional remarks, followed by a general Q&A section, and is expected to last no longer than 2 hours. Since we are living in an extremely quick digital world, preferable duration of the briefing is 80–90 minutes. I'm going to present each speaker separately before her presentation. So now I only name them: Olga Butkevych, Marie Hagsgård, Olivia Vedrin, Andriy Veselovsky, and Victoria Halenchuk. The organizers didn't limit speakers on a topic of their speech, except for a general topic of the briefing: national minorities' rights, international and domestic dimensions. It was done to show that the topic of national minorities' rights is extremely comprehensive, difficult, and has a lot of aspects to be discussed. But today, each speaker will have only 10–15 minutes to present, preferably 10 minutes, but in any case, no longer than 15 minutes. So sorry if I interrupt. About the Q&A section, I invite every participant to send questions to the general chat during presentations of our speakers. If you want to ask an exact speaker, please indicate his/her name. During Q&A section, after all presentations and additional remarks, I will read questions from the chat to our speakers. Also, you will have possibility to ask questions orally. Back to the topic of the briefing, I must emphasize its crucial importance for any state in general and for Ukraine particularly. We know that national minorities issues in any state may bring to serious tensions in the society, up to an armed conflict. We remember that the Russian Federation usually refers to national minorities' rights, trying to justify its occupation of the Crimea and its control over the so-called DPR and LPR. We understand that the actions and such reference of the Russian Federation is absolutely illegal, but it is our task to prove its illegality. On February 2021, the President of Ukraine stated that Ukraine must adopt a new law that will regulate the protection of their identity and equality of the national minorities. This law, as the President said, will provide rights to national minorities, but will also protect the territorial integrity and sovereignty of Ukraine. But as we say in Ukraine, it is easy to say, but difficult to do. because this law should be a compromise between state, national minorities, civil society activists, other states who are trying to protect national minorities of them in Ukraine, and many other actors. But in any case, this law should be in line with Ukraine's international obligations. And now I give the floor to the president of the Ukrainian Association of International Law, professor of International Law Department of Taras Shevchenko National University, member of the Expert Council on Ethnic Affairs of the State Service of Ukraine for Ethnic Affairs and Freedom of Conscience, a person who has experience of working at the advisory committee on the Framework Convention for the Protection of National Minorities of the Council of Europe, Olga Butkevych. Olga, sorry, you have to turn on your microphone. Yeah, I turned them all, sorry.
Thank you very much. And first of all, on behalf of the Ukrainian Association of International Law, I'm glad to greet here our estimated guest, President of the Advisory Committee of the Framework Convention of the Council of Europe, Mary Hagsgård, Professor Dr. Olivier Verdun, and Ambassador Dr. Andriy Veselovsky. As I'm speaking, I would like to consider the issue connected with the title of our meeting. I would like to consider the problem of correlation between international legal and domestic legal approach to national minorities and to the rights of national minorities. As far as both approaches are based on different visions of national minorities and of their rights. I would say that mainly international law is based on humanitarian, human rights vision of national minorities, whereas state approach or
sorry, I'm really sorry. I tried to turn off microphone of the other participant and did it accidentally. Okay. Sorry for it. But we heard almost everything. Sorry.
So I will turn that these two approaches are mainly based on rather different visions of national minorities. International law regards it on the basis of humanitarian and human rights approach and values, whereas domestic approach is based mostly on state sovereignty, state interest, or political interest of the states. So I will try to go through these two domains, these two dimensions of national minorities and vision of national minorities. So the first is international dimension. We know that ethnic conflicts are the most complex, most complicated and ambiguous as far as they are connected with very sensitive issues of religion, language, ethnic traditions, and such and like issues. Most states have problems with national minorities, and I would say that for a long time, for a rather long time, a state with its sovereignty and state with its political and other interests actually absorbed individual and groups of individuals as them are. Only after the Second World War, there was a breakthrough in the protection of national minorities, and it was started in international law. It was international law which, through the condemnation of the Holocaust, ethnic cleansings, and acts of genocide committed by Nazist and communist regimes, international law started to make this breakthrough in the protection of national minorities. At the same time, the ideology of the UN Charter and consequently the ideology of other universal international legal acts mainly considered national, ethnic, linguistic, and other issues only as a factor of non-discrimination. Emphasis was made on the equality of all people, the desire not to distinguish them on ethnic grounds as well as national grounds. In fact, direct protection of national minorities was lacking until the end of the 20th century, and we understand that that was the consequence of all these events of the Second World War. After two world wars of the 20th century, the collapse of the Soviet Union and Yugoslavia resulted also in mass conflicts, as well as including conflicts on national grounds and including ethnic conflicts. As a result, a lot of newly independent states which were formed after these two empires, or after these two, on the basis of these two states, Soviet Union and Yugoslavia, all these newly formed states, they obtained a lot of national minorities on their territory. So the need was to develop, to elaborate legal regulation of this issue. All these led to the need to appropriate international legal approach. So the Framework Convention for the Protection of National Minorities of 1995 was the first and actually the only document on the issue to date. At the universal level, no relevant multilateral treaty on the protection of national minorities has been adopted. I mean, no conventional treaty, no conventional document. Prior to the adoption of the Framework Convention of the Council of Europe, there was in fact only one Article 27 of the International Covenant on Civil and Political Rights aimed at protection of national minorities. Although the Declaration on the Rights of Persons Belonging to National, Ethnic, Religious and Linguistic Minorities, which was adopted by the UN General Assembly in 1992, was criticized for too general, too formalistic provisions of this declaration. Finally, globalization and international migration, including labor one, raised an issue of protection of national minorities, and today it causes the need for further regulation. So to sum up the international legal approach, I must say that the legal lacunas, as well as the absence of normative definition of the term national minority, caused that international protection of national minorities covers several groups of people, and it falls into the following categories. These are ethnic or pure national minorities. These are linguistic, religious minorities, and indigenous peoples. So now I would like to go to domestic level, or to national dimension of protection of national minorities, which is much more complicated than international one. Even now, the rights of national minorities are often considered by states, and as well as by public of the states in general, as so-called cultural rights. The rights to one's own language, research and study of one's culture, history, creation of artistic groups, national cultural centers, and etc. However, we understand that this is an extremely simplified and narrowed approach. The rights of national minorities include the whole range of human rights, including property rights, social, labor, and all other rights, which we can see from international legal dimension, international legal level of regulation of these issues. On the other hand, the rights of national minorities are often associated by the states and governments with the right to self-determination. And here, I would say that purely political speculations are also possible here. Such speculations, for example, as opposing the right to self-determination to the principle of territorial integrity of states. But even this reproach is demolished by international legal provisions. For example, the Framework Convention for the Protection of National Minorities aims to ensure comprehensive self-determination of national minorities. However, its provision in Article 15 states that it is about inclusiveness. It's about the duty of the state to involve representatives of national minorities in governing the state. So even the lack of representatives of national minorities, due to the wording of the convention and according to the practice of its implementation, is regarded as not consistent with with this practice and with this convention. So here we see that we are talking about self-determination within the state. As for me, on my opinion, self-determination, the principle of self-determination is not limited to creation of one's state, and even our creation of independent state, people did not finish their way on the implementation of their the principle of self-determination, as far as it also included self-determination on legal, political, and other ways of development of the state, of independent state, but that is something else. And here I would like to return to this question of state and etatist and national or domestic vision of national minorities and their protection. It is also about correlation of international and municipal vision of national minorities when we speak about what the rights of national minorities are, whether they are individual rights or collective rights. The question whether these rights are individual or collective is very important in order to see these two approaches or two visions, international one and domestic one. According to some researchers, for example, Thornbury, the Article 27 of the mentioned International Covenant on Civil and Political Rights is of a hybrid nature, and it lays down rights of national minorities in both collective and individual terms. In drafting of another document, the Framework Convention of the Council of Europe, the Framework Convention for the Protection of National Minorities, representative of the United Kingdom Monroe suggested that these rights should be considered as an individual right in individual sense, namely, instead of words national minority, to use the term persons belonging to national minority, which was adopted in this convention. And thus the individual nature of the rights of national minorities was clearly established. And that was completely in accordance with the state vision. I can say that when the question arose about the protection of national minorities in the second half of the 20th century, states treated with care national minorities as groups that could claim succession, and states usually were afraid of separatism. Therefore, they were quite willing to consolidate the rights of national minorities as individual rights. This has both advantages and disadvantages. For example, individual protection of a right was more effective, and it could be protected through international judiciary. On the other hand, a number of rights belonging to the group as a whole were lost. Today, in international practice, there is a tendency to combine these two approaches and to see rights of national minorities, to consider rights of national minorities both as individual and collective rights. Here we also may go to the interaction of international and national dimensions of protection of national minorities. Today, international law imposes two complementary requirements on states. The first is support for national identity of national minorities. The second is the promotion of the effective participation of persons belonging to national minorities in all spheres of public life. So on the one hand, we have the prohibition of assimilation. On the other hand, we have the need and the obligation of states to promote active inclusion of national minorities into the public life. Also, we may stress on the problem that many states do not recognize the existence of national minorities. Even some state parties to the Framework Convention of the Council of Europe have made reservations that they will recognize only certain national minorities or groups. Argumentation here is the following. The state has a single political nation which consists of all its citizens regardless of the color of skin, religion, ethnicity, and so on. There is also some advantages and real disadvantages of such approach. The desire to avoid discrimination on the basis of nationality also underlines the purely political interest of states. The political interest not to recognize minorities, not to recognize their rights. I want to stress also on international judiciary procedure as to protection of national minorities. The European Court of Human Rights has rather rarely addressed the issue of national minorities or the rights of national minorities. However, decisions directly related to the rights of national minorities have recently become more frequent. Here we may indicate some judgments in the cases of Ciobotaro versus Moldova, Molla Salli against Greece, Tashev against Northern Macedonia, and some others. Even judges of the European Court of Human Rights themselves emphasize that this is a gap in legal activism of the court, and more attention should be paid to the issue of protection of the rights of persons belonging to national minorities. So here also we may suppose to see a tendency that this practice of the European Court of Human Rights will expand. So to sum up these two dimensions, or these two approaches to human rights protection and protection of the rights of national minorities, I have two ideas. First is that due to some political and sovereign interests of states, it was international level and international law which was the first to speak about rights of national minorities and to impose to states the need to protect these rights and to elaborate the proper legislature. Also, I had a final section about Ukraine and protection of national minorities in Ukraine, but I'm afraid that I will use more time as I need. So I will be glad to maybe answer the questions or to touch upon Ukrainian situation during our discussion. So thank you very much for your attention, and thank you.
Yeah, thank you, Olga, and thanks for wonderful time management, because only self-limitation may help us to deal to do in a proper way. And thank you for your presentation. Dear participants, I one more time invite you to write questions to the general chat, and then after all presentations, you will have possibility to get answers to your questions in this really difficult topic. And you heard that sometimes we have obligations that it is very difficult to combine together at the same moment and to fulfill both of them. So really a difficult task. And now we are going to the president of the Advisory Committee on the Framework Convention for the Protection of National Minorities. And as I have heard earlier, a person who is practically implemented into the issue of national minorities' rights, indigenous people's rights, Marie Hagsgård. Marie is going to speak about Articles 6 and 12 of the Framework Convention of the National minorities and is going to explain how international law regulates these issues and how it can help states to protect national minorities' rights in a proper way. Marie, you are welcome. Yeah, but you have to turn on the microphone, yeah, because I muted all of you. Sorry for it once more. Yeah, so now we can hear you. Yeah,
yes,
thank you.
perfect. Thank you very much. Thank you for the invitation. It is a privilege for me to speak at your conference of the important topic of the rights of national minorities. And I've chosen Article 6 and 12 because I think it's very important in this difficult topic to keep focused on the goal for our efforts. I come from Sweden, and it's a country with 5 national minorities, and as was mentioned, the Sami, who are an indigenous people, are also considered to be a national minority. And I have specialized in Sami law, as I've been the secretary of 3 state commissions in Sweden dealing with Sami land rights and minority rights. I've also a background as a judge in Swedish courts. And actually, a year ago, the Sami won their first case in the Supreme Court of Sweden on Sami fishing and hunting rights. And now there is a new state commission trying to adapt the legislation to the result of that ruling. So it's for a lawyer in this field a very interesting time to live in. But for me, as the president of the advisory committee, I realized that the longer I work with the provisions of the Framework Convention for the Protection of National Minorities, the more important I believe it is that persons belonging to national minorities have the same human rights as persons belonging to the majority, because that is what the convention is about. They should have the same possibility to keep and develop their culture and their identity as persons of the majority have. And as was mentioned earlier, they should also have a possibility to influence the forming of our societies together with the majority population. Now, one may argue that in a democratic society, the majority population should decide about the future of society. But that is a very narrow perception of democracy. In the preamble of the Framework Convention, it says that we should strive for genuinely democratic societies. And a genuinely democratic society is one where persons belonging to national minorities can voice their opinion on issues which are important to them, and where their views and interests are taken into account by the majority when decisions are taken. That kind of democracy will create stable societies with less risks of conflicts and crisis. So, to Article 6, which is the goal of the Framework Convention for the Protection of National Minorities. In Article 6.1, it is stated that states shall encourage a spirit of tolerance and intercultural dialogue and take effective measures to promote mutual respect and understanding and cooperation among all persons living on their territory, irrespective of those persons' ethnic, cultural, linguistic, or religious identity. In particular, in the fields of education, culture, and the media. So, the means stated in this article are tolerance and dialogue, and the goal is mutual respect, understanding, and finally cooperation in order to create a good society for all to live in. Now, we all know that this is not easy, especially not when there have been conflicts or war. The experience of many states who have been in this situation, for instance, the people of South Africa, is that you need to deal with the past before you can take on the future. Truth and Reconciliation Commission of South Africa has become something of a role model. But when you have dealt with the past, you can start building mutual respect and trust, step by step, because it is not easy, in order to be able to cooperate in finding solutions that everybody can stand behind, or as it is said in our thematic commentary number 2, a shared ownership of decision taken. The first step may be solutions which everybody can accept and live with, and then maybe the next step will be a shared ownership of solutions. So in order to reach this, I also want to point to Article 12, which is about education. There it says in 12.1 and 2 that states shall take measures in the fields of education and research to foster knowledge of the culture, history, language, and religion of their national minorities and of the majority. In this context, state shall provide adequate opportunities for teacher training and access to textbooks and facilitate contacts among students and teachers of different communities. We have stated many times in the advisory committee that this kind of teaching of the history, not only of the majority, but also of the minorities, is vital to foster this atmosphere of dialogue and of cooperation. And actually, last year, in line with this, the Committee of Ministers decided upon a recommendation in order to include the history of Roma and travelers in school curricula and teaching materials. And I believe what they have said in this recommendation is also relevant for the teaching of the history and the present situation of other national minorities. So I encourage you, if you haven't done so earlier, to look this up and read its content. But some of the things that are pointed out in the resolution are that history teaching is one of the most important tools contributing to the elimination of prejudice and to promote the promotion of knowledge about different groups. The teaching of the history of Roma and travelers should not only include the history of discrimination and oppression and prejudice, which has been there, and which they still experience in our European countries of today, but it should include information about the contribution of Roma and travelers to our societies and refer to various aspects of Roma and travelers' history and culture, such as storytelling, literature, religion, music, and traditions. And also in the recommendation, it says that states are encouraged to give an opportunity to representatives of Roma or traveler organizations and communities in cooperation with schools to meet pupils and students in order to discuss and illustrate certain aspects of Roma and travelers' history and to provide testimonies. I really believe in this last part, that you invite representatives of minorities to meet pupils and to talk not only about the history, but also about the present situation that they live in society today. That will help to lessen prejudice and help us all to look for those solutions that we all can live with, or even feel will help us to create the society with respect for human rights of all. Another thing with this teaching of minority history is that we have heard when we meet representatives of national minorities that children from national minorities feel much more at home at school when they hear that the schools teach also about their history and their present situation, and where their contributions to our societies are acknowledged. Now, I want to mention a few things also about Ukraine. I know you are currently cooperating with the Council of Europe and the EU joint program, strengthening the protection of national minorities, including Roma and minority language in Ukraine. A specialized body in charge of coordinating all issues relevant to the protection of minorities has been established. And you are working with expert support and advice in the progress of drafting new legislative framework for the protection of national minorities. Dialogue and enhanced participation of national minorities in the decision-making at the local level is supported. These are good news because they are important things. And not least, I appreciate that you are working on legislation, and your Prime Minister has highlighted this, to protect the rights of national minorities. Because effective legislation will give persons belonging to national minorities the same possibilities as persons belonging to the majority to keep and develop their culture and identity. And in my view, that is one of the most important things you can do in order to build trust in relation to the national minorities. When they see, as a concrete result of such legislation being implemented, that they do have a voice and an influence, and that their culture and language and religion can be preserved and is respected by the majority, trust is built within the society. And I can mention, we have minority legislation in Sweden, but the national minorities there have a problem to see it effectively implemented. And I can see that it is important now for the Swedish state to really do something about this, or the national minorities will be very disappointed, both in the law and the lack of effects. So let me end by saying that the Council of Europe and the Advisory Committee monitoring the Framework Convention, the application of the Framework Convention in different states, is not about shaming and blaming member states for not living up to the provisions of the Framework Convention. But as I see it, it's about helping and supporting all states to do so. And of course, the goal for us all are European societies where the rights of both persons belonging to national minorities and the majority are not only accepted, but seen as a source of enrichment of our societies. Thank you very much.
Thank you, Marie. Thank you for such a comprehensive presentation. And really, we have a lot of questions. At least I have some of them, and I will ask you at the Q&A section. And thank you for your work and for work of your committee. Academy understands the necessity of your work, and we understand that you really and all monitoring and controlling bodies of the International Convention, they try to help the state to implement its international obligations in a proper way. But here we have few state servicemen, public servants, and sometimes they think in the other way when it's time to prepare a report to your advisory committee, and sometimes it seems like why do we need it, and how to prepare this report. Thank you very much.
Could I just add then that the last year, it started when Olga was a member of the committee, we have stressed the importance of follow-up meetings, and that's why I'm in Serbia today. We want to meet with the government, but also with academics and national minorities, and sit around the round table when the recommendations are there, and together discuss how we can implement the recommendations in concrete, practical measures to enhance the rights of national minorities. That's one thing. And the other thing is, don't forget, you academics, that you can send shadow reports to the committee the next time the Ukrainian government sends its state report.
It's understood, but you see that a shadow report should also be prepared. It's also a part of work. Thank you very much, and we hope to see you in Ukraine soon and to speak personally. Thank you very much. Now we are going to Olivier Vedrin, a person who has and had a lot of positions, and the list of his life and work on the Wikipedia page is simply impressive. So I even don't know how to present you: a professor, a journalist, a friend of Ukraine, or in any other possible way. So I simply give floor to you, and maybe you will say about you a little better than I do. So you are welcome.
Merci beaucoup. Merci. Then yes, you have everything on my Wikipedia. You can present me as a politolog. I think it's enough. Friend of Ukraine, yes, also. European activist, and as you know, member of the Russian opposition, also with my friend Ilya Ponomarev and Khodorkovsky, and so. Then you know, your topics is not very easy, and this is my friend Konstantin Sigov, who phoned to me from Kermogy Academy and asked me, can you say something about France and minorities? And first, this is not my topics, but what can I say is that in France we have France is a country where centralization is very important, and Article 2 of the French Constitution underline that French is the language of the French Republic. That's mean that our minorities with their own languages, because in France you have a lot of peoples. You have the Briton, you have the Provençal, you have les Auvergnats, Alsaciens, and all those peoples, they had for centuries their own language and own traditions. And the history of France is the centralization of this territory with one language. Then during century, and that increased with the French Revolution, they imposed one language, and really they did a lot to destroy all the other culture and minority and regional languages. And now in the 20th century, and because of the Open Union and because of the Council of Europe, a big pressure on France, they recognize the minorities and the several languages in the French territory. That was a big revolution in we call the Jacobinist way of mind in our elites. But now in France, you can learn your regional language when you do you study in the lycée and also in the university. But this is my generation. But the generation of my grandfather, grandmother, they imposed to them to speak only in French because of centralization of the French Republic. Then, but as I say to you, that changed because also about the European Union. Why about the European Union? Because in the EU you have this European Chart for regional languages and minority, and they push France to adopt this chart, but France didn't ratify. Only France takes some ratify some part of the chart, but not all the chart, because of this heritage of centralization. Now in France, I can say that, as I said, lot of change, because you can learn we can say Occitan language in university. You can say you can learn the old Alsatian language in university and in lycée. And also for minorities, for example Corsica, we gave to them a large autonomy. But you know, that's the story of France and the story in our French Republic. Between the part of politicians, we think that we have to centralize, and another part we think that we have to decentralize. And the decentralization in France is very difficult because the heritage is very centralization. And sometimes, you know, France is like a little bit with bureaucracy administration like the Soviet Union. We like to centralize everything. And for the minorities during the 19th century and the beginning of the 20th centuries, that was a nightmare because of this policy. And as I said to you, because after the Second World War, with the construction of the European Union, with the Council of Europe, those minorities and those regional languages were more respected. But in Article 2 of the French Constitutions, you can only have one language, French. And you know also that's very important in an international way, because France has also its own organization, Francophonie. This organization is like a cultural commonwealth, where you have all the former French colonies belong to this organization, and we use French like a tool of diplomacy. Then that's mean the language, the aspect of the minorities is very important in the psychology of French Republic. Voilà.
Yeah. Thank you, Olivier, and thank you for an introduction. So why does the French approach to national minorities is as it is? Because really we usually, maybe not usually, but at least sometimes pay attention to the French approach, yeah, with such not ignoring, yeah, but not separating something like national minorities rights from the rights of a human being. And we look at it from the legal point of view. Yeah, we analyze what does it mean in a legal way, yeah? But from such a political, politological way, it was very interesting to hear, and thank you for your presentation. And I foresee that in the Q&A section we are going to ask all our speakers about current situation in Ukraine, yeah, and what do they think about what happens in Ukraine now. And I think that point of view of Olivier from maybe political side will be very interesting for all of us. Thank you for your presentation. And now we are going to Andriy Veselovsky, a Ukrainian diplomat, ambassador extraordinary and plenipotentiary of Ukraine, advisor to the director of National Institute of Strategic Studies, and member of the Expert Council on Ethnic Affairs of the State Service of Ukraine for Ethnic Affairs and Freedom of Conscience. I have already mentioned the topic of his presentation, so really sorry for it. Suicidal nationalism, diplomacy to change a false pattern. So, Your Excellency, the floor is yours.
Thank you very much. Thank you very much for inviting me to your professional meeting. And well, I come from a different pack, from a different tribe. So I will dedicate my my talk to the diplomatic input into the problem. So why the name of this presentation, you will see it further. So on the eve of the demise of the Soviet Union in the beginning of 90s, Ukraine has been seen as the most problematic component of the rotten evil empire. Big enough to match the biggest European states, rich enough to compete with the continent's economies, populated and developed enough to man strong military forces, independent Ukraine has been viewed as an enigma by many and as a proverbial straw to crack the Kremlin's back. Coming to Kiev, then Kiev, on August 1st, 1991, US President George W. Bush made an infamous speech in the local parliament, warning Ukraine to remain part of the USSR rather than opt for, I quote, suicidal nationalism based upon ethnic hatred. The speech as such, known as Chicken Kiev speech in the diplomatic history, was welcomed by Ukrainians, while the assumption met indignation and was called, I quote, the worst speech ever by an American chief executive, according to the American Heritage magazine. By now, no suicidal nationalistic eruptions, no ethnic cleansing happened in Ukraine during her 30 years recovered independence. The country maintained friendly relations with all neighbors. The aggression of the Russian Federation of 2014 in the brackets, and implemented European-style legislation in the area of ethnic and cross-border contacts with the adjacent nations. The case clearly demonstrates, just a moment. The case clearly demonstrates how deep was the misunderstanding of the national character of the Ukrainians and how false was the image created by perfunctory historians and Soviet propaganda and their representatives in the West. It would be not fair to mention that there were numerous episodes of outrageous ethnic clashes and wars of national hatred in the long history of Ukraine, starting from late 16th century through the middle 17th century National Liberation War by Bogdan Khmelnytsky against Polish occupation, or the National Revolution of 1917-1922 against Russian communist aggression. To understand them properly, one would have to clarify the historical facts, purposely mixed with fabrication. Put Ukrainian history in the contemporary contexts of the religious wars in Germany or France, or massive deportation of the aliens to the concentration camps in Canada or US during the world wars, etc. One would have to thoroughly review the dwelling of Jews in Ukraine since the 10th century and their role in formatting national character, economy, trade, culture, and habits of modern Ukrainian nation. One would have to find better examples of international legislation promoting interethnic peace within the country and its good relations with neighbors, and introduce them to the Ukrainian society and the neighbors. This task has been assumed by the diplomats of the Ukrainian Ministry of Foreign Affairs, even earlier than the formal proclamation of independence of August 24, 1991 happened. The Declaration on the Principles of Cooperation in the Domain of the Providing Rights of National Minorities, that's the title, has been signed by Ukrainian Foreign Minister Zlenko and his Hungarian colleague Yasinski well before the independence, on May 31st, 1991. The signing allowed for installing the Intergovernmental Mixed Commission, facilitating implementation of the best European practices, put basis for creating a strong footing for the bilateral relations as a whole. The obligation of preserving friendly relations and respecting rights of national minorities has been codified by Ukraine and the Russian Federation in the Article 2 of the treaty between Ukrainian SSR and Russian SSFR of November 19, 1990, and reiterated in all further bilateral acts. Kiev's diplomacy reached out to their Polish colleagues, so the Declaration on the Principles and Main Development Directions of the Ukrainian-Polish relations was signed by respective foreign ministers on October 13, 1990, with Article 8 on national minorities' rights and guarantees. National minorities' rights have been mutually protected by the Article 6 of the Treaty on Friendship, Good Neighborhood, and Cooperation between Belarus and Ukraine of July 17, 1995, and Interministerial Ukraine-Moldova Agreement on Cooperation in Relations of the Nationalities of February 2, 1996. The understanding of mutual respect and free development of the national minorities between Ukraine and Romania, the title, occurred to be the longest story and was agreed only in the 1997 in the form of Article 13, the biggest one in the Treaty on the Relations of Good Neighborhood and Cooperation. The circle of legal acts aimed at the national minorities with the neighbors was a real achievement of the Ukrainian diplomacy. Becoming a member of the Organization for Security and Cooperation in Europe, OSCE, in 1992, and cooperating with its High Commissioner for National Minorities, Kyiv initiated an OSCE mission in Ukraine in August 1994 to support her sovereignty, territorial integrity, and internationally recognized borders, focusing on the situation in the Autonomous Republic of Crimea. This initiative has been made in respect to the territorial claims on the Crimea by high political and military persons in the Russian Federation. The mission successfully implemented its mandate and finished operation in April 1999. With the further amendments of the international legislation on national minorities' rights, the named bilateral documents have been modified or deeply remade, mostly by the initiative of the Ukrainian side. All subsequent ministers of foreign affairs of Ukraine, started from Zlenko to Udovenko to Tarasyuk to Hreshenko and so on, paid utmost attention to the topic, taking into consideration the historical smell about Ukrainians as a destructive, nationalists, and anti-Semitic nation. It is very important to mention why such a smell existed and how it continues to propagate in spite of the clear absence of the nationalistic policy or organized activity or porous legislation allowing national hatred or inequality of the people of different nations, ethnic groups, or religious communities in Ukraine. Historically, being a de facto Polish colony during 2 centuries, or later, the Russian colony in times of the Russian Empire, Ukraine was a territory where classic divide et impera policy was applied in both religious and national aspects. Stuck in the middle between local peasants and foreign landlords, Jews and other minorities were the first obvious victims in times of wars, uprisings, calamities. However, when Ukrainians could form their own authority, things were quite different. Jews made high proportion of the government of the Ukrainian National Republic in 1917, 1922. They participated in the anti-Soviet formations of the Ukrainian insurgent army during the World War II and enjoy great prominence as governors, ministers, prime ministers, and president of Ukraine in time of recovered independence during the last 30 years. The false narrative of Ukrainians being suicidal nationalists, Nazi servants, and anti-Semites come from Moscow sources from the first day of communist dictatorship and didn't change the tune after the demise of the Soviet Union. The same narrative goes about Baltic nations or the Georgians. By doing so, the authorities of the Russian Federation tried to offset their internal policy of Russification brought from the Soviet times in today's practice against small and non-Russian nations in the Urals, Siberia, and Volga region, or the inter-ethnic hostilities in the North Caucasus, or the repression of the Crimean Tatars on the ethnic basis in the occupied Crimea Peninsula of Ukraine. Being responsible towards the international obligations and willing to preserve internal peace and productive interaction between the title nation and the minorities, big and small, as Russians, Hungarians, Poles, Romanians, Crimean Tatars, Czechs, Jews, and others, the Ukrainian diplomatic service is tasked with learning best international practices on the matter, listen to the advices of the respective international bodies, and inform government and the parliament on the way to improve the legislation. Thanks to their efforts, a special project strengthening the protection of the rights of national minorities in Ukraine, which has been mentioned today, organized by the European Union and the Council of Europe, has been launched in 2018. The input of these Ukrainian diplomats in bringing the attention of the country's leadership to the ethnic and religious relations was crucial, especially at the pre-independence period and during the first years of the sovereign statehood, and should not be underestimated. Having been actors in international politics and working with UN and other international bodies, those people knew well the price of ethnic tensions and conflicts and ways to avoid such a scenario for Ukraine. And just to sum up, I would say that nowadays the diplomats of Ukraine continue to play a role in introducing the understanding of the importance of national minorities problematics and strengthening relations with neighbors and solidify national unity to better cope with the aggression by Russian Federation and other challenges of the volatile world politics. So thank you very much for listening.
Thank you, Your Excellency. Very in-depth presentation, and really from the point of view of diplomatic service, because really the Ukrainian diplomats, they have a very difficult task, how to reach understanding with neighbor states and how to protect this unity inside Ukraine. So thank you very much. So we had 4 key speeches, but we also have additional remarks. It's something new for the briefings of the Ukrainian Association of International Law, but today we have co-organizers, the State Service of Ukraine for Ethnic Affairs and Freedom of Conscience. And now I give the floor to the analyst of this service, Victoria Halanchuk. Maybe not to sum up our briefing, but to bring our attention to the issues important for Ukraine and for the persons who are responsible by their position to protecting national minorities' rights. Victoria, you are welcome.
Dear distinguished speakers, dear participants of today's briefing, let me thank you for your thought-provocative and well-grounded speeches. I have a privilege to talk today on behalf of the State Service of Ukraine for Ethnic Affairs and Freedom of Conscience. And firstly, I would like to express gratitude to the Ukrainian Association for International Law for cooperation in organizing this highly important meeting. I would take this opportunity of my remark to introduce our state service first, and then I will make several remarks regarding our today's discussion. So to start, the State Service of Ukraine for Ethnic Affairs and Freedom of Conscience is a central governmental agency which was established in 2020 to strengthen governmental capacity in monitoring, analytics, mediation, and awareness raising in the fields of ethnic and religious affairs. It was registered as a legal entity in March 2020 and has begun performing all of its functions since September 2020. Our state service perceives its mission as a mandate to promote openness, responsibility, goodwill, and unity in diversity of Ukrainian society. The statute provides our state agency with functions of designing draft legislative acts, communication and exchange between various national minorities, as well as fostering cooperation with kin states of national minorities residing in Ukraine through the Ministry of Foreign Affairs of Ukraine. Besides, one of our aims is to raise awareness within the society and central as well as local government regarding national minority and integration issues. In this regard, we are very thankful to the Council of Europe for providing us with relevant thematic webinars in March of this year. The state agency is committed to facilitate communication with persons belonging to national minorities and organizations that promote their interests to ensure that citizens' concerns are heard and they receive sufficient consideration when public policies are developed. Ukrainian legislation is based on the principle of national minority self-identification and promotes equality of citizens. There are over 100 ethnic communities. Throughout 2020 and 2021, aiming to gather opinions and issues from ethnic communities, the State Service has held more than 30 meetings with ethnic communities and established contacts with more than 120 NGOs of ethnic communities. We also work closely with the Ukrainian Cultural Foundation, with the Coordination Center for National Minorities Broadcasting of the National Broadcasting Company, the Crimean House, as well as with the Ministry of Education and Science of Ukraine. These bodies have special mechanisms to support minorities and their activities from the state budget. For example, public funds are committed annually to ensure that there are opportunities for national minorities to learn and to be taught in their native languages. For example, in the current school year, more than 1,700 students are being taught in one of the native national minority languages. Ukraine has also started to implement projects of multilingual education with the support of the Office of the High Commissioner on National Minorities. And well, some successes have been already achieved. Also, it is very important for us to provide sufficient representation of people belonging to national minorities in local governmental level. So that is why there are consultative mechanisms for national minorities at different levels of executive branch. For example, there is a special council of representatives of public associations of indigenous peoples and national minorities of Ukraine at the Ministry of Education and Science of Ukraine. Besides, there are 17 consultative bodies at regional state administration, comprising exclusively of the representatives of national minorities. So this was a little introduction of our state service, and now please let me address today's discussion now. I would like to refer to the 12th activity report of the Advisory Committee of the Framework Convention, which is devoted to the challenges to the democratic societies and minority rights, including the rise of populism. It is true that this tendency can also complicate interstate cooperation regarding minorities and even result in practices that does not correspond to the Article 21 of the Framework Convention. The ongoing Russian armed aggression continues to be our permanent challenge. So now we meet issues and new challenges which might seem very unique for Europe of 21st century. We have to deal now not just with minorities and minority-majority dimension, but with minorities internally displaced to the places of compact residence of other minorities, or to the intercultural cities, or to the places when majority presents a majority, or where majority presents a minority actually. Given this complicated situation, we continue doing our best to maintain tolerance in society and satisfy needs of communities. Currently, we are preparing a midterm framework governmental document aimed at meeting demand of communities and providing integration of the society. Besides, we are also working on legislative changes. Given that there is no common practice among the Council of Europe member states regarding the format of legislative regulation of minority rights, I mean laws, strategies, and so on, and also with regard that demands of communities residing in Ukraine vary, we are considering to start with governmental interventions first and then move to the legislative level. However, these processes can go in parallel. I would like to finish with the Roma issues, since it is a highly complex topic that is very prominent in our activity. After the expiration of the strategy for the protection and integration of the Roma national minority into the Ukrainian society and the action plan for its implementation that were in action till December 2020, our state agency, building upon international recommendations, suggestions from governmental agencies and Roma NGOs, developed a new draft governmental document for the next 10 years term. Despite the quarantine measures due to the COVID-19 pandemic, most of the activities prescribed by the action plan for the realization of the strategy till 2020 have been ongoing. The accurate information is already provided on our website and will be included to Ukraine's periodic report. And today we have already mentioned the periodic reports and monitoring procedure. So please let me assure you that we are finalizing our periodic report to send it to the Council of Europe soon. And we consider the monitoring mechanisms as a really highly important thing to improve our governmental policy regarding rights of national minorities. Dear colleagues, thank you again for your time and interest, and I hope for further discussion.
Yeah, thank you, Victoria, for your additional remarks and information on I don't know, we need an abbreviation of your institution in English. So in Ukrainian it is DES, but in English it sounds a little unusual. Yes, so because to say the state service of Ukraine on, for ethnic affairs and freedom of conscience is a little too long. Yeah, thank you very much. So now we have to open the Q&A section. As I see, we do not have questions in the chat, but we remember that Olga Butkevych wanted to add something to her presentation about the situation in Ukraine. And I also have at least one question. This question arose when I was listening to Marie's speech, but it is, I think, to all of our speakers, what to do. So Marie said that we need a dialogue. Yeah, we have to sit down and to communicate what is to be done to protect national minorities. Yeah, but what to do when these national minorities do not want to communicate? Yeah, when they say we have a right and we do not want to hear anything about limitation of this right, and please don't call us minorities. Yeah, we are not minorities, we are the same citizens as you are, but we have a different ethnic origin, for example. So they even do not like being called minorities. Yeah. So what to do? What advice do you all have? Yeah, to solve this problem? How to explain that we really need a compromise, and it is impossible to imagine a situation when the national minorities' rights are fully protected and they are satisfied, but we have a problem with integrity, with unity in the state. So I think let's start from my question. I will use my rights as a moderator, and then we'll go to Ukraine. I see that Marie has an answer, so please.
Yes, I think this is quite a common problem in a lot of countries, that you try from the majority side to get in contact with some minorities, but they don't. I think there is a lack of trust between minorities and the majority. So in our second thematic commentary on effective participation, we have one piece of advice, and that is that states should support the building up of organizations representing national minorities. They need knowledge, they need economic support to represent themselves in a way that you can start a dialogue. And we have a very good example of what can happen when that works. And that is one of the experts of the advisory committee. He's a traveler from Ireland, Martin Collins, and he leads a traveler organization called Pavy Point, and they were even given a prize by the organization for Peace and Security last year for the best organization of minorities. And what they have essentially done, Martin himself lives in a mobile home, and he has gone to school for until he was 12, and then he left school. So he hasn't had a long education, but he really wants to bring forward his group's concerns. And when we were in Ireland, he brought us to a settlement where travelers have tried to tidy the place up, but they have no electricity, no running water, and so this is what they wanted. But anyway, he instead of saying, I'm the leader of the only organization of this community, Pavy Point has gathered different organizations representing travelers in Ireland, helping them to put forward their concerns. And then they've gone to the government and different NGOs and presented their concerns. And it has been so successful that they have been acknowledged as a national minority. And also they had this international prize for being effective in taking part in the dialogue with different stakeholders. So that would be, and I think with Roma and travelers, we have the biggest problem because the lack of trust is so great. You know, I used to be a judge in the criminal court. So I've had lots of criminal cases where families of Roma come and check out what I'm doing. And then I know that after my court hearing, there is a special court hearing within the Roma community, and that is the important one. So I think it's a lot about step by step building trust and confidence in the dialogue. And then as a next step, you can accomplish solutions to different parts of the problem. And the first step is to support those good forces who want to build up the organizations representing the national minorities. Yeah, thank you.
Yeah, thank you for your answer. And I see that Andrei wants to add something.
Thank you. First of all, let me say that it was very, very interesting, and especially I paid attention to what Olivier said about the French experience. So we need to clarify that the situation in Ukraine and France is very, very different, because what you call national minorities is not our national minorities. Only so-called Lemki or Rusini in Ukraine can be compared to the French so-called national minorities, because our problematic national minorities are those who live normally in the adjacent countries. So we have here two different groups, and we need to act with them differently and recognize it always. But about the question of Roman, well, I have three good answers. What to do with those who don't want to communicate: diplomacy, diplomacy, and diplomacy. And you have to talk and talk and talk, and always communicate to the others that you talk. Always inform in international institutions and other minorities, and the nation as a whole, that you talk. And finally, the minority understands that everybody knows that they do not communicate. And it's a sort of shameful feeling, which would allow them to change the policy and start to communicate. So diplomacy, diplomacy, diplomacy. Sorry.
Yeah, thank you very much for such a brilliant answer. And I'm sure that being a member of the expert council of the State Service for Ethnic FES and Freedom of Conscience, you also do it. Yeah, and thank you very much. Victoria, you want to add something? Am I correct?
Yes, thank you. I would like to I try to be short. I would like to share some experience to illustrate this thesis about the power of diplomacy. What our state service has started to do with communities is communication. Due to COVID-19 pandemic and all these quarantine restrictions, we've started regular Zoom meetings. So since autumn and till now, we already held, as I mentioned, like near 30 such of meetings. But actually there is one problem. The first one is trust, because when you talk via Zoom, it's less confidential than you talk with people alive. And the other thing is that we gathered people from one particular community throughout Ukraine. For example, Romanians in west of Ukraine and in other regions of Ukraine. Well, this is a very valuable experience, but we talk only to one community, which is dispersed. Recently, I had a very nice experience. I was privileged to travel to some regions in the south of Ukraine and participate in more close meetings with representatives of different ethnic communities, but who reside in one particular territory. And I can say after such meetings that every community, even if it is a very close community, for example, like Meskhetian Turks, there is always one person who is active and ready to cooperate, and not because this person has some personal interests, but because this person really wants to make something valuable to community. So building bridges which such persons, with such close communities really may be a cure, but I agree that it is a rather difficult and long-term process, but we should think strategically and look much beyond ourselves. Thank you.
Yeah, thank you, Victoria. And I see that Olivier also has something to add. Olivier.
Yes, to speak about France, I know that France is not, this is not the same, we have not the same problem than in Ukraine. This is minorities are not a national minority, they are French, and but you know, they belong to some region with different language and different cultures. But I think what I wanted to say is that if languages and minorities, this is almost the same, you know, a nation, a people has its own tradition and languages. And I think the example of France is good, in some ways. That means our regional entities, they can learn their tradition and their own language in university and in school. And that's, I think it's a nice step for diplomacy. Secondly, they can learn their own language in university and school, but French is the only language of the French Republic. And I think we respect now those languages, but those entities, regional entities, they have to respect the French Republic language with French. Then I think for Ukraine, that can be a way of thinking the relationship between the tradition of minorities in Ukraine and languages in Ukraine with the relation with the Ukrainian language. That means the Ukrainian language is not here to break the tradition, and other language is the language of the state, and the state respects the other language. Like in France, you can learn Occitan language in university. And I think this is tolerance, you know, that means this is beginning of diplomacy. And also but you had that before, Crimea had a large autonomy in the Ukrainian nation, and like Corsica in French, they have a large autonomy. Then I think in the past, when Crimea was not occupied by Russia, Crimea, I think, had a large autonomy, and that's they had their own cultures and that. And I think Ukraine, you know how to do that, because they did that with Crimea before. And I think you have everything to be successful, to promote your own language and to respect the other languages in your country. Thank you.
Yeah, thank you, Olivier, and thanks to all participants for such a live discussion. But I would like to back to Olga's ideas, what to do in Ukraine, and I think it would be a great end of our briefing. So, Olga.
Thank you. Thank you. But in order not to spare a lot of time, I would like just to sum up my vision of the Ukrainian situation. I would divide the situation in Ukraine into 3 levels. The first level is legislative one. Here, in all 3 levels, we have both advantages, disadvantages, positives, and negatives. Speaking about legislative level, we have a positive because Ukraine recognizes all national minorities. Unlike other countries, which some countries which don't recognize national minorities or recognize only part of them or only just some groups or minorities, Ukraine recognizes all the minorities and indigenous people, and that is due to Constitution of Ukraine. As to negatives or disadvantages, we have a very, very out-of-dated legislation. The law of Ukraine on national minorities was adopted in 1992, even before 2 European conventions, Framework Convention and European Charter on Minority Languages, and even before Ukrainian Constitution in force. So this law does not, it just contradicts to Ukrainian Constitution and Ukrainian international obligations. At the same time, I don't think that we have legislative vacuum in this sphere, as far as due to Ukrainian legislature, when there is a lack of national domestic regulation, we may be governed by international provisions and international obligations of our countries. So here, in this case, we have also both advantages and disadvantages, but sure that new legislature is in time, highly in time. Another level is institutional level. Until 2010, there was the State Committee of Ukraine for Nationalities and Religions. It functioned from 1996. It functioned under different names, but it was liquidated, and after its liquidation, the lack of proper institution in charge of minority issues, in charge of all these issues. In 2019, the State Committee, State Service, let me just call it DES from Ukrainian, because it's rather hard to make some abbreviation in English. Therefore, in this level, when this new state service was established, here we have just some positive changes. So that is the next institutional level, and I can see here some positive developments. And the third level, I would call it everyday level or social or household level. That is a level of everyday life. And here, unlike and in contrast to rather good developments in institutional level and even in legislative level, here we can observe some negative things. We can observe hate speech, anti-Semitism, xenophobia, racism, and other negative manifestations of intolerance, both in media, which is very common. Unfortunately, it is common for many countries, and even in different domains of everyday life. So that is a problem which should be tackled and which should be we have to do something about this problem. And to sum up, I would return to legislative level. Today we have 2 bills. One bill is about that is a bill of national law on national minorities, and another bill. Tomorrow it will be discussed in Ukrainian Parliament, in the Committee of Ukrainian Parliament, the bill on indigenous people of Ukraine. My proposition is somehow different. I think that due to the questions which are very sensitive, which are very delicate, all the questions connected with, all issues connected with national minorities, with religious, linguistic, and ethnic issues, they're very sensitive. And in this case, and due to the situation in Ukraine, I think that the algorithm should be a little bit different. At first, we should elaborate and establish a general framework document document, general framework mechanism, which will provide for basic principles, basic ideas as to ethnopolitics, as to rights, status of national minorities and indigenous people. We understand the national minorities, indigenous people, these are two different objects of regulation, but this huge document, this framework document may provide us with some basic outlines of future legislation, and that could give us the stage of so-called verification, I would call it verification of the appropriate outlines and appropriate actions of the state and society as to national minorities and indigenous people. And on the basis of such framework document, it is possible to elaborate systemic and complex legislation on national minorities and indigenous people. And I can say that even such an algorithm could we serve as an example to other countries, to other states which have this similar situation and as in Ukraine in this domain of national minorities. So that were my propositions and that were my ideas as to Ukrainian situation. Thank you very much once again. Thank you.
Yeah, thank you very much for such overview of the situation in Ukraine. So, dear participants, maybe somebody has a question to ask. No questions? So, the briefing already lasts for 97 minutes. So I think that it was very productive. We had extremely interesting, comprehensive, and in-depth speeches. I would like to thank all participants on behalf of the Ukrainian Association of International Law, on behalf of the State Service of Ukraine for Ethnic Affairs and Freedom of Conscience. And we invite you to join our further briefings. I think that we will turn back to the issue of national minorities rights in the nearest future, because maybe we are going to have a new law to regulate these issues, and we'll have to discuss it and what to do with a text adopted by the Verkhovna Rada of Ukraine and how to live with it. Thank you very much for participation and see you next time. Let's hope that we do it personally and not via Zoom, but we'll see. So